Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. How we doing, guys? What is up? What is up? I hope you're having a wonderful December, end of the year jitters or whatever. Woo, as we hold on, I'm setting my windows. As we work to close out 2023, for some, a monumentally shit year, and for others, probably pretty good, which is about as ambiguous a statement as you can make, which is, of course, the best way to always be correct. Right? Right. I think so. All right, here we go, guys. We've got some good topics tonight. Trump has been removed from the ballot in Maine. We're going to talk about that. Texas versus the United States government, specifically the Department of Justice on the border. On the border, Texas passed a law not too long ago. And I was actually going to cover this and talk about it, but now I have a more compelling way to talk about it because the U.S. Department of Justice, I believe, is the entity, is threatening to sue Texas if they actually enforce their new law. Now, the law is basically Texas saying, well, if the federal government isn't going to fucking deport people, Texas is going to deport people, right? Like that's the idea, because they say we have a border. The government has this federal statute that says they have to enforce these border laws. They have to do it, and the executive is not doing it. The executive branch is not faithfully executing the laws of Congress and is not enforcing on the border. So Texas says, we'll do it. We'll protect our own state's rights, reminding the federal government that all rights and powers of the federal government are borrowed from the states and its people. So now we're going to have a showdown with normally easy to answer question of federal supremacy. But federal supremacy is easy in principle and difficult in practice. And the fact that the federal government is not actively practicing several of the laws on the border makes the question a little more complicated. In the same manner, but definitely distinguishable from the federal government trying to exert supremacy on something like the Controlled Substances Act in regards to marijuana, which the federal government now for something like over a decade, I believe, has been failing or has refused to enforce marijuana laws in states that have legalized it, right? Where normally you would say, well, the federal government has supremacy there and the Controlled Substance Act controls. When you have this effective promise to not enforce, if the states make it illegal, regardless of what the federal law is, then you now have a question of whether federal supremacy can outdo the states who are acting in reliance on that sort of executed promise. If the federal government suddenly goes back and starts enforcing, I mean, people are acting as if it's legal because the government has basically said it is. Well, now we've got this issue with immigration that is obviously not linearly applicable, but is in the same ballpark. And that is very weird. It's very interesting. So we're going to talk through that theory crafting here. This is kind of uncharted territory, and we have some conflicting ideas and concepts, and they don't really align easily with the classic idea of federal supremacy. Normally, the border enforcement would be a plenary authority of the federal government for a federal border. But if they fail to enforce, their arguments against the states start to narrow down, and you have to wonder, like, what subsequent power they're relying on to fail to execute the federal law. We're going to theory craft on that a little bit, talk through it. This is all, these are going to be novel arguments in some ways. And the answer may just be that this is plenary authority the federal government and the state loses. That's the easy answer for the Supreme Court. But the question is, do they want to have an easy answer here? Or will they craft something more specific? And the border has been a long unanswered question with the Immigration Naturalization Act being largely unchanged for quite a while over the party's inability to reconcile some differences and make compromises. And, some people would say that's good. Some people say that's bad. I think our immigration problem is not in a good state. The problem, though, isn't just a disagreement over law. It's a disagreement over the enforcement of the law. Because if they just enforce the existing law, many requests of many people would actually be completely fulfilled. They just don't do it. So we'll be talking about that. Very interesting discussion, in my opinion. And then we've got this other kind of a fun topic. If you remember, the Supreme Court struck down affirmative action in university admissions. And there's an article out there about how that has affected law school admissions. Now that they can't just check yes for black, right? Like, because that's what they were almost effectively doing is minority student check yes, unless they're Asian, then it's like, get the fuck out. That was the practice. And they're complaining because they want to do that because it's never been more diverse. As if diversity in and of itself is intrinsically valuable. It is not. It is not intrinsically valuable or invaluable. It is subjectively valuable or not valuable. And so with the goal of diversity, then obviously a diverse outcome and a diverse mindset is beneficial and desirable. But that's only if the goal is diversity. If the goal is a robustly educated class, then diversity doesn't serve that goal until you try and ham-fist in abstract ideas like, well, a diversity of backgrounds amongst the student body creates a more robust learning environment with a broad range of experience. Like, but that's not necessarily important to the application of law. That might be important to something like philosophy and I know law is partly philosophical, but realistically, law is reading, synthesis, application, and argument. It is not, well, what is this supposed to be? Unless it's supposed to be your client's position. So diversity doesn't necessarily serve that purpose. And you still get a naturally diverse populace when you just try to serve the purpose of law. In my opinion, diversity is our strength, I guess, except it doesn't seem to have any necessary value. And in fact, sacrificing certain characteristics that are favorable to the study and practice of law in favor of ethnic background doesn't really serve clients in the long run and may actually be creating a less prepared class of, attorneys. So we're going to talk about that because I just, some of the statements in there are mind blowing in how frank they are. And yet it's framed negatively. So I love that. But here's the kicker. I set up this show. And then I did something very stupid, which is not recommended to anybody. Now, before you judge me for what I say next, before you judge me for this next statement, you have to understand that it is not meant in the way that it's going to sound at first. And you have to follow for my subsequent explanation where I qualify to undo what I've done. My biggest mistake after setting up this show was clicking on Good Logic show. My good friend Joe Neerman, I clicked on his show out of an abundance of curiosity. And it was one of the worst decisions I've made in a while. Now, some people think that's a slam at Good Logic. It is not. Great. A very good friend, a great broadcaster, a wonderful streamer. But he had on his show today motherfucking Pisco. And I don't know, like every time I see his name, my brain literally inserts motherfucking in front of his name. It's always motherfucking Pisco. Every fucking time. He has Pisco on the damn show. I think Pisco is now a lawyer, a licensed attorney. I think so, but I don't actually know. Last time I talked to him, he was a third-year law student or he just graduated. I don't know. But when I talked to him, it was about the abortion question, Roe versus Wade, really. It was the question of Roe versus Wade and should there be some protection for the unborn, et cetera, et cetera, et cetera. And that was on Destiny's show, and it ended up being me versus 3 lawyers effectively on the abortion question. And obviously, I won that debate. It wasn't even hard. But that being said, Pisco was on today talking about the disqualification of Trump with Joe. And I just don't know how to describe that without slurs. Like, I don't know how to describe it without immense amounts of profanity and uncouth language. So I'm debating if we should watch part of that. Like, if we should watch it or not. Or if I should just scream about it. Because all I wanted to do the entire time was scream. It was mind-numbing. It's so fucking bad. Or maybe I'll rant about it a little bit in the abstract and then do a EFAP of it next week. Maybe that would be good. But the amount of insane assertions that this guy made in the short period of time that I'm watching, and then he accuses other people of just asserting conclusions. But his claims are nuts. He claims that Article 3 of Section or of the 14th Amendment, Section 3 of the 14th Amendment, is self-executing. It ignores that Section 5 of the 14th Amendment specifically empowers the federal Congress to make laws to enforce the provisions of the entire amendment. And he says, no, it's self-executing. And no, Article 3 or Section 3, I always say Article, Section 3 of the 14th Amendment does not have an enforcement provision in it. In fact, it has a restorative provision by which Congress can reinsert someone as a eligible candidate. Let's ignore the fact that the 14th Amendment, Section 3, has no application to a president by its express text, not by the naming of positions that are disqualified for office, and similarly and subsequently, not by the express text of the oath to support the Constitution. The President of the United States does not take an oath to support the Constitution. Every other office listed does. Every other office listed in Section 3 takes an oath to support the Constitution. The president does not. So, we have 2 express omissions of the president. First, by name, and second, by oath. Yet Pisco asserts, out of nowhere, that it is a self-executing clause to disqualify a president who participates in an insurrection. But the problem is participation in an insurrection is not self-evident when an insurrection isn't self-evident. And January 6th, by no prior definition of insurrection, qualifies as an insurrection. And in fact, likely qualifies expressly as protected First Amendment activity in the general nature of it, with specific crimes committed during protected First Amendment activity that go outside the scope of protected activity, just like every other fucking protest on the planet. If you are properly executing and exercising your First Amendment right to peaceably assemble, to speak and to petition your government for redress of grievance, then there is no wrong action. Now, if you exceed that and are no longer peaceably assembled, then individually, following due process, you may have a conviction that overshadows your rights only by a jury of your peers in criminal court. An insurrection is a criminal offense under the law. Not only has Trump not been charged or convicted of an insurrection, he has not been charged with participating in any kind of insurrection. And the only thing that even comes close is a finding of fact and conclusion of law by a Colorado district court that states an insurrection occurred and Trump participated in it by clear and convincing evidence, which is not the evidentiary standard of any criminal conviction, is outside the jurisdiction of where the act took place, and further has a fucking federalist issue with the jurisdiction of a state court ruling on federal law from 1,500 miles away with no witnesses to the federal act. What the fuck are we even talking about? And Pisco suggests that this is a self-executing clause. Well, if it was a self-executing clause, there wouldn't need to be a finding of fact and conclusion of law that Trump participated in insurrection, except to the manner that the state would be recognizing, specifically a federal conviction from the DC circuit on fucking point. But they don't have that. Instead, they have a finding of fact and conclusion of law based on bullshit. And Pisco is always all too happy to shovel bullshit into his goddamn fat, stupid mouth and then spout off about how correct he is. Oh my goodness. Look at the amount of federal rights this motherfucker shreds in the rabid pursuit of making Trump an insurrectionist to justify his removal from the ballot in Colorado and Maine. It's the stupidest shit I could ever imagine any attorney expressing a constitutional background to have. But hey, motherfucking Pisco. Motherfucking Pisco. So, whew. It's amazing. It's amazing. And it's not unique to Pisco, right? Like a bunch of people are all too happy to just shred all pretense of due process, shred all pretense of your 4th, 5th, and 6th Amendment rights. Well, Trump's 4th, 5th, and 6th Amendment rights because he's an asshole or whatever, I guess. I guess that's what it means. Like, wow, he's an asshole, so I guess he doesn't get this. And Joe is actually raising very, very good arguments. Now, not in the way that I would, right? Because I would have just screamed a long time ago. Because Pisco is maddeningly inaccurate in how he interprets the Constitution and then states it as a truth. And he's like, well, yours is a conclusion, so I think the burden's on you. It's well, no. The burden is on you to show where Trump participated in an insurrection. First, you have to show an insurrection occurs. Then you have to show that he participated in it. Where's the insurrection? And I know it's stated over and over in the media for the dim-witted morons out there to sit and scoop up into their fucking Cheerios that Trump used criminal acts to subvert the peaceful transition of power. But anyone with a fucking newspaper archive can find that there was no interruption to the peaceful transition of power, which would happen again. What is it? I can't do math. I'm not Asian. 15 days after January 6th, without a hitch, in which Trump participated in the inauguration in his constitutional role. I fucking saw an article that specifically suggested that Trump did not participate in the inauguration. It's like, motherfucker, he was right there and executed his constitutional role of ceremonially handing power over to Joe Biden. There's a real question on if a president can refuse to hand over power in any meaningful and legal way, maybe, or if it is, again, a ceremonial role of the president to participate. Like, if the president isn't there, is the next president inaugurated? Probably, yeah. But even so, he was there and handed it over, and he did not object to the peaceful transition of power. It never stopped. It never hiccuped for a moment. All pending questions legally and constitutionally were resolved prior to January 21st and the inauguration. And anyone who says otherwise should have a fucking skewer through their goddamn brain, because they're so retarded and so hell-bent on this position that they just won't look at explicit fact. It's explicit fact. It is. Man, looks like I picked the wrong day to stop drinking. What the It's stated ad nauseum in every media publication. Obviously, the entire purpose of this is to brainwash and propagandize the populace into the conclusion that Trump somehow interfered with the inauguration. It's not January yet. No, but I can start early. It's good. It's amazing. It's amazing. How do you combat just rampant willful idiocy? There is no interference in the transition of power. Trump's ability to interfere in the transition of power is questionable at best. Any president, absent an execution of military authority to delay the inauguration. Someone who can delay the inauguration and has delayed the inauguration, if I'm not mistaken, is the vice president. The vice president, in reading the electoral votes and certifying them, which they tried to say under Pence was clearly a ceremonial role, but has not traditionally been ceremonial. Maybe it is now. Who knows? Maybe we have to answer that question. In the past, if the vice president does not certify the electoral results of a state and returns them to the state for investigation, recount, whatever it is, that can delay an inauguration, has. But that is the vice president's role. And it is informed by objections from members of Congress in the constitutional process by which all of this occurs, by which was being executed on January 6th until the insurrection actually stopped the process and then caused members of Congress who were going to object to states that had not been read yet to change their mind and to not object. If anything, the transition of power was preserved by the acts on January 6th, albeit unwittingly. But in any case, they had no prospective ability to continue to interfere in so much as they interfered through January 21st. And I would challenge anyone to suggest how a group of unarmed citizens who walk peacefully in some cases and then push violently in other cases, without guns, without supplies, was going to take over the halls of Congress and hold it down and prevent an inauguration 15 days later. How is this going to happen? By what practical mechanism does the National Guard not just go in and just go, brep? The only reason that the January 6 people were not literally mowed down in a hail of gunfire in the halls of Congress? Reasons, there's a couple. One, really shit PR. Really shit PR if you put down a political protest, even one that was as violent as the January 6th one. And that's giving all deference to all reports of violence. But even one as violent as January 6th, mowing people down in the halls of Congress, not a good look for just about anybody involved. Possibly sparking something like a civil war, or at least severe civil unrest. By the way, what's up to Good Logic and his raiders? We're just talking about Pisco. We're just now talking about Pisco. But had they mowed down the January 6th interlopers in the halls of Congress, bad PR. The other reason they didn't is because, questionably, until the narrative fits, very strong exercise of First Amendment rights. And then furthermore, there wasn't a sufficiently violent push to warrant that level of violent response. There just wasn't. In fact, the response to one person, Ashley Babbitt, being shot in the halls of Congress was so inflammatory and so questionable that the idea of mowing down an entire crowd would have been unfathomable. It would have looked like the tyranny that it was. And looking like tyranny is the one thing they always want to avoid while they're enacting tyranny. But had the January 6th protesters walked into the halls of Congress carrying long rifles, shotguns, and other firearms, shooting at Capitol Police, or even threatening and brandishing at Capitol Police, what would have happened? We might have seen them mowed down in the halls of Congress, and people wouldn't have objected. If they had lit the White House, if they lit the Capitol building on fire, what would have happened? If they had gotten a hold of a senator or a congressman and actually put them in danger, or grabbed Mike Pence, what would have happened? Gunfire, blood in the hallways. National incident. But there's a reason none of that happened. It's because none of that fucking happened. Because it doesn't look like an insurrection, because it wasn't an insurrection. It was a group of people disagreeing with an election and the results, whether they are correct or incorrect. Their right to voice that disagreement is unquestionable. Now, what is questionable is how many laws were actually violated by individuals. Because remember, collectively, we cannot violate law. You cannot violate law as a collective. You must be tried individually with the right to defend yourself based on your actions. Now, are there ways to aggregate actors into an act? Well, yes, we have people who are accessories. We have people who engage in conspiracy. Of course, there are specific conditions of criminal law that allow people to be grouped together, but the defense of those positions is individual. And there are situations where two co-conspirators can be found simultaneously guilty and not guilty of a conspiracy, which is pretty interesting. But it has to do with what level of proof the government has. So with all of that, you cannot collectively assign an act to a group of people. They must be individually processed and prosecuted with sufficient individual probable cause to raise charges and sufficient legal basis for each of those charges backed up by evidence. And I pity anyone who has to live under the country that says otherwise. So, did Donald Trump engage in an insurrection? Maybe. How do we find out? If only there was some mechanism by which a person can be tested, maybe by like a group of 12 people, with some facts and argument presented as to how they fall under this criminal schema. If there were only some system that we had that could do this, if only someone had thought of it. I guess we'll just have to sit and wonder of what would have happened if there were some system by which criminality could be determined that was in the Constitution, but there just isn't. There just isn't one. It's insane. It's insane. And the amount of people who fully buy into this idea. Oh, yeah, of course he did. Of course he engaged in an insurrection. Like, wait, what? Do you even know what that is? Do you even know what that means? And then let's ignore all, again, that's ignoring the underlying textual problems with Section 3 of the 14th Amendment. Just as a recap, which does not include the President of the United States, expressly does not include the President of the United States in the list of people who are not eligible, and also by including a different oath than the President says. But I digress. And yet you have someone out there purporting to be a lawyer, just making the constitutional argument that the 14th Amendment is completely self-executing. There is actually an argument that Section 3 of the 14th Amendment, I'm going to say but was fully self-executing. The argument that supports the 14th Amendment, Section 3 being fully self-executing, necessitates that the 14th Amendment, Section 3, was a one-time provision that could not be applied in the future. The argument would be that it was so self-evident that the insurrection being referred to is the Civil War, in which all of the participation in the Civil War is expressly identifiable. And the list of officers, representatives, senators, and delegates to the president and the vice president that is listed there is so obviously conclusory because everybody who did that is known. It is known, right? Like Khal Drogo. So you could say that Section 3 of the 14th Amendment is self-executing, but only insofar as to the existing, obviously self-referential insurrection that had just occurred and ended a few years prior, and that the amendment was directly referencing. But to suggest that any quote-unquote insurrection in the future would be similarly self-executing is folly, because what even is an insurrection? An insurrection is not an act of war that is found by Congress. And we have a problem, right? Because there is actually reference to an insurrection in the Constitution. Does anybody remember what that is? Oh, yeah. Yeah, the commander-in-chief, I believe, can call upon the militia to suppress an insurrection. Did the commander-in-chief call upon the militia to suppress an insurrection? Ooh. And doesn't that fundamentally suggest that the commander-in-chief cannot participate in an insurrection? Because if the commander-in-chief is required to suppress the insurrection and no one else can order a National Guard or a national militia, I guess the national militia at the time, to suppress an insurrection, then it seems to indicate that a commander-in-chief cannot logically participate in an insurrection, because how does one insurrect themselves? Now, I know what people are thinking. They're like, well, what about, I can hear it. What about, yeah, what about it? Oh, it's like we have a couple different provisions to remove a sitting president from office. It's almost like A president cannot insurrect against his own administration, but in case that he manifested an act of insurrection, he would be impeached and removed as president, and then would no longer be recognized as having the power he would no longer be recognized as having the inability to insurrect his own administration, because by his actions that were impeachable, he had no longer maintained control of the administration. Now, practically, of course, an impeachment takes time, and the impeachment result would occur sometime after the insurrection events. But that does not mean that the power of the president would actually follow to the time of the execution or the conviction under impeachment. The acts themselves would be sufficient to remove the authority. And then, according to the Constitution, a president could be prosecuted. So it's almost like if Donald Trump had been impeached for an insurrection, like if that had happened, and then at his impeachment trial, he lost and was removed from office for the insurrection, he would be found to have participated in an insurrection. Because that actually does exist. That mechanism does exist. And they tried it and they fucking failed. Now, why did they fail? Oh, yeah, because they just could not show that it was an insurrection. They can't. And I know they're like, well, but it's only because the Republicans wouldn't do it. Yeah, because the Republicans didn't agree to a sufficient number that it was an insurrection. Why not? Because Republicans didn't really trust that fucking vote either. But the amazing thing about this is all of this is actually laid out in the Constitution. And there isn't any reason, there is no reason to try and go to outside arguments, to go into these abstract ideas, because all of it is expressly within the text. And it does not support the idea that Donald Trump could have participated in insurrection in any way, absent an impeachment on the issue. He was impeached on the issue. They did not find him guilty. Therefore, he cannot have participated in an insurrection. He just can't. I would love to see someone confront that argument and come up with some way, sensically, that he can. What's up, Aurora Uplinks? Have a good night. But I don't know. That's just like my opinion, man. It's just like my opinion. But I saw Pisco on Joe's show. I sent 3 super chats to participate in my limited capacity in the discussion. And Pisco's responses to all of them were terrible. So that's what I got. I may EFAP part of Joe's show, not tonight, next week. Or maybe we'll bring Joe on or something to talk about it next week. Man, it's fucking unreal how people get into this. Now I've heard a couple of people reached out to me and said that Destiny would like to talk to me about the January 6th stuff. But he'd said on his show that I'm difficult to schedule a show with, which is true. But I will reach out to Destiny and see if I can make myself available. I really, I think I had to bail on Destiny's show last time. Like I wasn't home for some reason. It was very unexpected. Or I had something come up where I was going to like leave. I don't even remember specifically what it was, but I know I had to cancel. I felt really bad about it, but I'll reach out and see if I can schedule something with him. I think is he going to be debating Alex Jones or something about it? I think I heard that, but bring Pisco on yourself. Oh, dude, I know. YouTube has an anti-bullying policy. your boy H.P. Lovecraft. I'd probably get banned forever. But yeah, as far as like Destiny and I think someone framed it as like a debate. I would probably approach it more as a discussion. I've had good chat. Like, I don't have a problem with Destiny to the point where, like, I do have a problem with Pisco and his argumentative style. I'd be happy to give my opinion to Destiny and he can do with it what he wants. I guess if we got into like the debate mode, we could, but I try not to approach discussions that way. I'm a big fan of approaching discussions as discussions until the other party decides to do something else. Oh, he's debating Alex Jones and Glenn Greenwald on January 6th. Like, wait, on January 6th? That'll be interesting. But yeah, I'll see if I can reach out and find a time. December's been very busy. After New Year's, I think I have a little bit more flexibility. Anyway, we'll deal with that. Destiny used you and Joe for retarded streams against his retarded lefty friends. That doesn't bother me at all. That doesn't bother me in any capacity, but all right. Let's hit a couple of these super chats and then we're going to get into the main topics of the night and we'll see how we do. Jason of TGA with 3 Rumble rants right up the gate. He says, imagine that their Reichstag fire attempt ultimately carried a rainbow flag and Starbucks soy latte. Merry Christmas and Happy New Year, champ. Hey, you too, buddy. He also says self-executing a special meeting for Canadians now. Oh, damn. And then he says, with all the lawyers and politicians talking garbage, seems almost like if they saw an actual insurrection, they might poop themselves and not be on camera talking garbage at all. Oh, they are very, very scared of an actual insurrection. They're very scared of what happened on January 6th because it wasn't an insurrection. Man, yeah. Oof. January 6th thing is still pisses me off. Like I'm not on record, not the biggest fan of January 6th. I think it gave quote unquote the other side all of the tools and ammunition they needed. There's not any particular person to blame except maybe that Ray Epps guy. Them. Ooh. But the crowd just gets riled up and does a thing. It's how crowds work. It's one of the big risks of it. Bad choices were made by some people and shit went south. But that being said, that does not make it an insurrection. That does not make it automatically incorrect. And it does not invalidate the arguments or cries of the people screaming out. But they want it to. They want to do that. Because if they do that, then they can continue to oppress. Alex Jones was on the Jimmy Dore show today for 3 hours. It was an awesome show. Hopefully it brought some populism factions together. I need to get Alex on this show. I'd also like to talk to Owen Schroyer again now that he's out of jail. I was on InfoWars a couple times on Owen's show and on Alex Jones's show, and they're great. Had a nice time talking to both of them and would love to do it again. I got invited back right before Owen went to jail and I just couldn't make it. I think I was in Florida at the time, so I couldn't make it. But yeah, they're on my list of people to talk to again in the near future. Scott Roush says, next year looks spice. I have my popcorn. I'm ready for whatever show goes on. Well, one of them I saw Locals is mentioning the Courtney Clenny trial. That's the OnlyFans girl who stabbed her boyfriend in total self-defense. Happening down in Florida. I think that trial's been delayed to February now. So that's going to be fun. And then Trump's Georgia criminal trial, unless it gets stayed pending a question of criminal immunity from the Supreme Court, will be March 3rd or 4th, I think that's supposed to start, and is promised to be broadcast happy to stream that one. I will clear my schedule for that one as much as possible. That trial will be one of the most important events in recent history if it goes through. I actually have a doubt that it's going to happen, though, because I do think that the Supreme Court is going to have to rule on presidential immunity. And I do think that there is a real federalism issue with a state holding a president to a criminal conviction over some kind of election interference question for a president ostensibly and under a reasonable perspective investigating in his capacity as the chief executive allegations of election fraud. I think it would be hard to argue that Trump's actions in Georgia go outside the bounds of the outer perimeter, as it were, of presidential acts. So if that's the case, and if they use the same model that the civil presidential immunity comes to, what you have is civil immunity basically being a separation of powers question. The judiciary cannot hold that power over the executive. And similarly, a state cannot hold that power over the executive as well. And I think that's going to be a big topic as we get, or a big portion of the discussion as we get into this Maine topic, the topic of Maine excluding Trump from the ballot. Tom Grawl says, in China, wishing you the best for the new year. Hey, thanks, Tom. Enjoy yourself in China, and Happy New Year to you, brother. He also says, although there is no bourbon here, there's no bourbon in China. You're the big fans of Scotch, the Chinese. So maybe you can find some Scotch, even though there's no bourbon. Jackie Jones says, preach. Thank you. The Minuteman says, I was deployed federally after January 6th by the Illinois National Guard for the insurrection. There was literally no point to go at all, and I didn't see any people who were violent. There was no point in us being deployed. Well, there was for their political purposes, my friend. Just Joy says, please schedule a show with Stephen Gosney. Well, I would love to. And there's a topic that might be, well, no, actually, strike that. There's always topics that are good for Stephen Gosney, but December has been such a mess for me, and it's been hard to schedule much of anything. But JD, thank you for being a member for 20 months at the paralegal level. Although you have like a gold badge, not a bronze one, so maybe that's wrong. Who knows? Thoughts on starting a hot dog company called Ann's Franks? Well, only if they're kosher, I think. All right. Let's do this. Jim Doyle says, proud to be a future Civil War veteran. Oh, no. Don't say they're going to get banned. Let me get this Maine story pulled up. We'll get that going. Here we go. Where is this? In the Maine story, well, there's a couple things going on here, but we also have a little update in the Colorado ballot measure. It is being that order removing him from the ballot is actually being suspended pending a potential appeal to the United States Supreme Court. Now, these appeals are going to get aggregated in, obviously. Although there's a little difference here that we're going to talk about as we go into this Maine question. It is different than Colorado. So Jim, oh wait, I read that Jim Doyle one. Thank you. And there's two more over here on Rumble. Shredder S07 says, Nick, I know a lady charged with aggravated assault with a weapon happened in her home. Victim was trespassing. Always more to the story, but would love to know how a Shasta lawyer preps for a case like that. Aggravated assault with a weapon in her home. I mean, the basic self-defense arguments. She was in reasonable fear for her, of imminent death or serious injury. Depending on what's stated in, you may have to establish that she exercised all possible avenues of retreat before being forced to defend herself. The questions are, what did she say to the police in the aftermath? Because self-defense involves 3 incidents of defense. You have your initial proximate physical defense of your life. That is the act that involves typically utilizing violence against a person who is aggressing on you. Then you have the immediate aftermath, in which you are going to start establishing your legal defense by not saying anything that compromises your claim to self-defense, which is why you should say very, very little, and have competent counsel help you navigate that discussion that follows. And then finally, your ultimate defense will potentially be in a court of law if you are charged by a district attorney or indicted by a grand jury. So if that happens, you would have your third level of defense. All three of those stages are independent, although interlinked, and all of them are critical. And a lot of people end up losing their self-defense claim when they do on that second stage, where they make statements to the police ostensibly in their defense or in their explanation. And when they make those statements, they say things that compromise their claim, like asserting they weren't scared, asserting that they always carry a gun so they don't have to live in fear, asserting that, maybe they had seen it coming and planned for it, or, whatever. There's a story recently of two guys who hidden their home or one of their homes during a robbery. They believed someone was going to come and commit the crime on their property, and they waited, and then they shot them when they came in. And they, I believe, just received 40 years or something in prison for murder, because they basically laid out a plan to kill someone. A lot of people disagree with that conclusion. And that's fine. There's a really good, there's a good argument to be made that someone routinely breaking into your property is an ongoing threat to your safety sufficient for violence. I'm not going to state that it's not, but legally, you're on very shaky ground doing anything like that. And, that has gotten many of people in trouble. The other thing that gets people in trouble in those circumstances is how they act beyond the initial defense. There was that story of a guy in Minnesota who he knew people were breaking into his house frequently. And he kind of set it up so that they would break into his house. They came downstairs. He was waiting. He shot them in defense of himself and his property. But then what happened after that was he executed them after neutralizing any potential threat. And that is what ended up doing him in. It was also recorded, and he sounded like a crazy man on the recording. But those circumstances of how you proceed in the aftermath are what determines it. So it's really going to be fact specific, Shredder. It always is. They have to articulate a reasonable fear of imminent death or bodily harm. They have to articulate their subjective fear of the same thing. And then they have to have no statements compromising those things to the police. So, Jason of TGA says, with all this evidence the communists have on Trump, criming around as he does, you'd kind of think they would have him under control by now, unless they are retarded communists. It's amazing. Trump is one of the most observed people on the planet before he was president, became politically exceedingly divisive before he became president, as he started to indicate that he would ran as president, and then for the next 4 years acted as president in a manner that was so inflammatory and infuriating for such a large portion of the country, and they still have not managed to pin anything on him. I mean, think about that. Like, that's wild how much shit he should have against him, and they just can't do it. Shredder SO7 says, also, I'm not a metal fan, but stumbled across Sleep Token and wondered if you heard of / listened to them at all. Here's some cash for your thoughts and future shoulder transplant. Yes, I mean, at some point, someone will probably want my shoulders, and I'll be happy to donate them, to science or whatever. I've never heard of Sleep Token. Maybe Steve Gosney has. He's much more of a metallologist than me, but I can check him out. He says they're pretty good. I've never heard them consciously. James Gartner says, great show always, buddy. Buy a crippled stripper and some Fireball. Ew. Oh, man. I hate Fireball. Oh, that's gross. Oh, it's so sweet and sickly. All right. Here we go. Maine strips Trump from the ballot, inflaming legal war over his candidacy. Activists and voters have filed numerous lawsuits around the country claiming the former president is barred from office under the insurrection clause. Is that what? That's an interesting subheading here, I think. Let's check it out. Maine's top election official ejected former President Donald Trump from the state's ballot on Thursday, declaring him ineligible to serve as president because of his role in the January 6, 2021 attack on Congress. Wait a minute. Maine's top election official? That doesn't sound like a court case. The ruling by Maine Secretary of State Shenna Bellows Your last name is Bellows? Shenna? I wonder how you became popular. What the fuck? We're going to do it. We're going to do it. Oh, God. Oh, okay. I'm not even going to do that to y'all. Okay, here we go. Yeah, back to this. Shenna Bellows. Woo. Okay. A Democrat, weird, is certain to inflame a roaring national debate over whether the Republican presidential frontrunner should be allowed to hold power again. Allowed to hold power again. As if any of these people have the authority to disallow someone to hold power. Your ability to run for president is a right. It's a right. Contingent on a couple conditions that are expressly listed in the Constitution. The removal of that right is a deprivation of rights requiring due process, and everybody's just ignoring it. There's a literal constitutional clause. Here's how you become an eligible candidate. This is all you have to do. If X, Y, and Z are present, then candidate, then eligible. You can't just strip them. Joe brought this up to Pisco, but he just didn't get it. And the funny thing is, Joe, again, it was such a reasonable point by Joe and very nicely brought up, but there are tons of rights that are instilled by government. And once they are instilled and recognized, then taking them away becomes a deprivation. For example, your right to vote. You don't actually have a right to vote for the president, right? But once they granted a right to vote, once the states passed this law that says this is how we will do elections, we will let the people vote under these circumstances. Once they do that, to then take away your right to vote, to deprive that requires due process. You have to be deprived by a felony, for example. Same thing with the presidency, being an eligible candidate for president. The conditions are express. They're simple. And to deprive someone of them requires due process. It requires notice and opportunity to be heard. And it requires, you would think in the case of an insurrection, you would think it would require specifically a conviction or a criminal burden of proof at the minimum. All right, here we go. The decision makes Maine the second state in 2 weeks. It could have just said the second state to disqualify Trump's candidacy due to the constitutional bar on office holders who supported or engaged in insurrection or rebellion. Last week, the Colorado Supreme Court barred Trump from the state's Republican primary ballot under a similar interpretation of the 14th Amendment. Bellows was given permission by the Colorado Supreme Court. That's what happened here. Bellow's decision on Thursday increases the pressure on the U.S. Supreme Court to step in and ultimately decide Trump's fate. They were always going to have to step in. As the Colorado GOP petitioned the justices this week to do. So, yes, Colorado has, or the Colorado GOP has petitioned the Supreme Court to answer this question. They're appealing the decision made by the Colorado Supreme Court to the federal government. Well, to the Supreme Court of the United States. Well, I got to find something here. Okay, perfect. There we go. So Bellow's decision on Thursday, I just read that. Unlike the Colorado ruling, this one comes from an individual office holder affiliated with the Democratic Party. I mean, this is the Pisco argument. Self-executing, therefore, a Secretary of State of a state is invalidating a president. Trump can't hold office. Why? I said so. Wait, what? How? By what mechanism does the Secretary of State or the state of Maine have the authority to do this? Don't know. No one knows. No one can identify the authority by which this secretary is acting. But here's the interesting question, right? Let's hypothetically suggest that Maine can do this to the president. If you believe that Maine as a state has the authority to determine a president ineligible under Section 3 of the 14th Amendment, how do you subsequently determine that the Supreme Court can disagree with the state and force them to return him to the ballot? This is one of these logically inconsistent stances. Because if Maine has the authority is derived from a specific provision that effectively states that states are in control of their own elections, right? They will prescribe the time, place, and manner of the election for president. It's controlled by the state, or of the selection of delegates, we'll say. So Maine says he's disqualified. We have the authority to say he's disqualified because we have we select our own delegates in our own way. Well, now you have this issue because Maine has done this. If the Supreme Court intervenes, you have two problems. One, if Maine has plenary authority over who is on their ballots, then the Supreme Court cannot tell them otherwise. And then two, the other issue is that the Supreme Court does not have the authority to reinstate a president who is ineligible. And this becomes a real conundrum. Because does anybody remember who actually has the power to reinstate an ineligible president? It's in the text. We're in the text, y'all. 2/3 vote of both houses of Congress to reinstate an ineligible person. There is no Supreme Court authority to reinstate someone who is ineligible. SCOTUS can't do it. It is a plenary power of Congress expressly given to the legislative branch. So how do we resolve that? If the Supreme Court tells Maine they can't have him on the ballot, does Maine get to say, fuck you? If it's a plenary authority of Congress, then the Supreme Court can't tell Maine to put Trump on the ballot, but Congress could But then Maine would lack the authority to remove him from the ballot because it's a plenary authority of Congress. There's a huge fucking problem here that cannot be logically resolved with the conclusion that an individual state has the authority to remove a president from the ballot. You just can't. It's inconsistent internally. If Maine does that, the Supreme Court can't make them undo it. Only Congress can. But if only Congress can do it, Maine can't do it in the first place. So the only conclusion must be that Maine lacks the authority similarly to Colorado. It's the only logical outcome that exists with the language of Section 3 of the 14th Amendment. There's no other way to do it. The Supreme Court cannot recognize a state's ability to individually do this. Because then Congress would have to respond to any state on any candidate for a Secretary of State's individual political determination. Think about how cumbersome that is. Let's say in every single subsequent election, one state's Secretary of State says, I find this president ineligible for the ballot under whatever reason. Maybe it's Article 3, maybe it's something else. I find the president ineligible. Well, now Congress, by 2/3 majority vote in both houses, has to overturn a state in every single election for a candidate, which means that one state in every election can hold Congress hostage. That can't be a reasonable act of governance. It's not something that holds up in efficient governance, in practical governance. It doesn't in any way seem to comport with the principles of federalism or a Republican form of government. How can any of this happen in the way that they want it to? It don't make no sense. My opinion, the only logical conclusion is that there has to be a federal criminal conviction for an insurrection, which would have to follow, according to the Constitution, an impeachment that was successful for insurrection. That's the only way you can show that a president would be guilty of insurrection. Oh, but wait, let's just find the easiest, most sensical, and logical way out of this. The only one that matters is this. The 14th Amendment, Section 3, does not apply to a president of the United States. Done. Easiest ruling, and here's why. The president is uniquely situated under any of the other aforementioned positions because it is the only ubiquitous federal position that would be directly impacted disproportionately by any state's refusal to include them on a ballot. Every House of Representatives member, every senator, every delegate, or all of those positions that are elected positions that would have an ability to strip someone from holding office by a ballot measure are localized to the state making the decision. No House member in Colorado could be impacted by the decision of a Wisconsin Supreme Court or a Wisconsin Secretary of State, which means that Colorado deciding not to put a Colorado citizen on the ballot as ineligible under Section 3 of Article 14, sure, go ahead, do that to them. That kind of comports with the language of the Constitution at least more thoroughly than a president. But if one state can remove a president from the ballot at its whimsy, then it is now impacting 49 other states and the voters of 49 other states just by its own independent, autonomous act. But it's almost like the drafters of the 14th Amendment maybe had considered that and thought, how can we let some determination somewhere impact everywhere on these national positions. Now, remember, officers of the United States are different because officers of the United States, not including the chief executive officer, as some people might call it, officers of the United States are appointed. They're nominated by a president, and then they're confirmed by the Senate. Well, now we have a different question, right? If they're nominated and they're not eligible because they are participating in an insurrection, then the Senate could simply make their vote to go ahead and approve them and pass to the House the question of the cure. Will the House support the Senate's 2/3 vote? Again, these are reasonable, simple solutions that go right in with the drafting of the Constitution and don't require a bunch of ass backwards fucking gymnastics to somehow support the position that one state can do this without any authority to make this determination. And again, ignoring Article 5, which says that federal Congress would make laws to comply with this. And again, ignoring that it obviously does not apply to the president. It can't logically do so. Okay, we're going to keep going. We're going to keep going. In Maine, unlike Colorado, has been a presidential battleground in recent years. Under an unusual state law, it cast one of its electoral college votes for Trump in both 2016 and 2020. Trump was quick to attack the decision, with an aide calling it partisan election interference. It is, but his removal from the ballot in 2 states remains a stark illustration of his deep legal and political vulnerabilities. They're not deep legal and political vulnerabilities until the Supreme Court has spoken. Bellows, who made the call in Maine because state law requires the secretary to adjudicate ballot challenges to candidates' eligibility, defended her decision in her determination. Quote, "I'm mindful that no secretary of state has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment." Bellows wrote, "I am also mindful, however, that no presidential candidate has ever before engaged in insurrection." This is very, very questionable, isn't it? If Trump engaged in insurrection, certainly you could find a president who engaged in some level of insurrection, according to their political opponents. The decision will almost assuredly be appealed by Trump, but by becoming the second state to kick Trump off the ballot, it marks a major milestone for effort by activists to bar Trump from seeking the Oval Office again, breaking out of the confines from an isolated incident in one state to the beginning of a pattern. Okay. What? Bellows at times offered forceful arguments around Trump's political conduct as a defense of her decision. Trump's occasional requests that rioters be peaceful and support law enforcement do not immunize his actions, she wrote. Trump was aware of the tinder laid by his multi-month effort to delegitimize a democratic election and then chose to light a match. Those are just words. She did, however, pause her own decision to strike Trump from the ballot in the state, pending an appeal to the state judiciary. Activists and voters have filed numerous lawsuits around the country claiming that Trump is barred from office under the 14th Amendment's insurrection clause. That clause states that anyone who, quote, engaged in insurrection or rebellion after taking an oath of office to support the Constitution is forbidden from holding any public office. Again, support the Constitution should be in quotes because it's not in the presidential oath. And actually, this is not true. Ah, fucking damn it. Okay. It's not no person, or it's not any person, not anyone. It is anyone having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States. You have to fall into this list. You have to do that. It's not anyone who has taken an oath of office to support the Constitution. Theoretically, there could be some other thing, but I'm nitpicking now because it's annoying that they took the quotes out here, but support the Constitution is the fucking quote. Bellot's decision followed an hours-long hearing in the state earlier this month, in which Trump's attorneys argued that she doesn't have the discretion to make a decision on Trump's eligibility and that he hadn't participated or aided in an insurrection. The challenge to Trump's eligibility propels Ballot into the spotlight in an unusual way. You mean in a way that is politically and personally advantageous to a politician of an opposing party to Donald Trump? That way, many of her Secretary of State colleagues across the country have similarly been pressured to kick Trump off the ballot, but they've argued that the courts, not election officials, are the proper jurisdiction to make that call. And that's actually incorrect as well. But Maine state law effectively has Ballot serve as a quasi-judicial role for eligibility challenges that many of her colleagues do not. In a statement, Trump's campaign spokesperson Stephen Chung attacked Ballot as a former ACLU attorney, a virulent leftist, and a hyper-partisan Biden-supporting Democrat. He said the campaign will quickly file legal objection in state court to prevent this atrocious decision in Maine from taking effect. Bro, you got to go to the Supreme Court immediately. A second state invoking the 14th Amendment to block Trump from the ballot makes it even more likely that the nation's top court will step in to adjudicate the dispute. No, they had to do it after Colorado. They have to. Colorado's justices pointedly noted that they were unlikely to have the final say. Quote, we are also cognizant that we travel in uncharted territory and that this case presents several issues of first impression. The Colorado majority wrote, the Colorado court temporarily stayed its own decision to give time Trump to appeal these to the Supreme Court. I guess they just forgot to edit that. On Wednesday, the Colorado GOP did just that, which means Trump will likely appear on the Colorado primary ballot while the high court deliberates if or how to decide the case. Bellot's references the Colorado case in her explanation, writing that her, quote, decision could soon be rendered a nullity by a decision of the United States Supreme Court, adding that fact does not relieve me of my responsibility to act in furtherance of my own personal political interests. And that's critical here. This is critical because this is her propelling herself as a Democrat politician into the national spotlight. Also on Wednesday, Michigan State Supreme Court ruled that Trump can appear on the state's primary ballot, finding that the Secretary of State there did not have the power to make that determination. While a significant legal headache, the Colorado ruling further rallied Republicans to Trump's side. Following the ruling, President Joe Biden said it was self-evident that Trump supported an insurrection, but that whether the 14th Amendment applies, I'll let the court make that decision. It's self-evident, Joe. Again, look at the tyranny. A criminal conviction of your political opponent is self-evident. A deprivation of right of your political opponent is self-evident because they're your political opponent. It's really fantastic. Just the concept of all of this is phenomenal. It's a remarkable time. Now, don't get me wrong. I'm obviously passionate about this topic in this way, but I'm also extremely excited because I love challenging questions surrounding the separation of powers, constitutional powers in general, the powers of the president. Fascinating topic, not tested most of the time. Because I've talked about this before, but briefly, all of government operates largely on this weird handshake agreement that everybody just goes along with it. And there are rare instances where a challenge between two different interested parties is made. And once that happens, we get a real showdown. We see who has the fucking balls, right? Who's got the balls with the most pee in them to win the fight? And that question is always neat. And what happens after changes the country forever. This is no different. There's a lot of these questions around Trump right now, which is just fascinating, and I love it. But I am very passionate on the application of the 14th Amendment not applying to a president for so many obvious reasons. And then subsequently, that even if it did, it certainly doesn't apply here, absent several steps that need to be taken to provide due process. Luis Velez, no, pee is stored in the balls. Why do I cannot believe people still don't know this biological reality. It's very frustrating. All right. JNP Jr. 1980 says, former YouTube chat name Juan, sending my first super chat here in Rumble because fuck censorship and fuck YouTube. Still angry over when what Kev Fails tried to do. Keep doing what you do. Well, I plan to. Here we go, guys. We need to go ahead. We're going to flip over to Rumble. Speaking of Rumble, we're going to flip over to Rumble in just a second here. I'm going to read the YouTube super chats and we'll take a little pause as we get over to Rumble. It'll be grand and wonderful and great. Make sure you come join us over on Rumble by following the link that is in the description of the YouTube video or the pinned chat by Jay Liebgott. Come hang out with us over there. Much more to come. On your way out of the YouTube stream, though, please, if you like the show, go ahead and click like. Go ahead and slap that little thumbs up button. And every time you do, it puts a physical thumb up a Democrat Secretary of State's asshole, and they go, ugh. Again. Oh, I called you Luis. It's Luis Velez. Heather Reed says, but I just got to know, do you love black people? Yes. I love black people. Do you love black people? Unironically, they're hilarious.
Do you love black people?
Yes, Jesse. Yes, I do. Yes, I do.
I just need you to be black and a female.
Well, I am. All right, guys, let's hit these super chats and then we will pop over to Rumble. Is Drex coming to my place for New Year's? I don't think so. And I don't know if I'm going to be home for New Year's or not. I don't know what our actual plans are yet, which is weird because it's coming up pretty damn quick. Here we go. McChilla says, my nipples are hard. McChilla says, you must acknowledge my hard nipples. I just can't take it anymore. Everything has crumbled since Jack Murphy fell. Make clucks great again. Ewan Faramir reads, a toast to my son born today, Patton Garand, was born December 28th at 11:39 a.m. 7 pounds, 12 ounces weight, 21 inches long. I'm very tired and shall now go to sleep. 30 hours of labor is too many to stay up for the show. Oh my, listen to the commitment. To Eowyn Faramir reads, a cheers to your son, Patton Garand, born, well, technically yesterday now, my time. Born at 11:39 a.m. on December 28th. At a healthy weight, healthy length, after 30 long hours of labor, breaking his way into the world past the tyranny of the labia, as he have freed himself. May he become the self-reliant man he was destined to be. Cheers to him, a healthy delivery, a healthy childhood, and a great future. All right, here we go. 24 Cookie 24 says, you're forgetting one key variable in the Trump stuff. How will the judges and reporters afford their luxury homes they get from the wealthy elite? That's a good question. It's a good question. Ginger Ninja, Nick, I wasn't able to stick around till you read my chat the other night. Are you going to try to have Robert Gavea on to talk Donald J. Trump cases, especially that amicus brief on Jack Smith's legitimacy? Hope to see it. Yes, I would love to. Hopefully sometime soon in January. I'm trying to get through December on my in my personal life because it's so busy. So all day tomorrow. Birthday parties for my daughter. It's gonna be great. Scott McGinnis says, frustrated in a blue state, but we will not quit. Free Turtle Boy. The police state is pulling us off to jail. Yep. Shut up, I can cook. says, hi, Nick. I demand a live trial and uncivil law. Well, the next trial will hopefully be Courtney Clenny in February. We'll see. She also says, please, Nicholas, please bring uncivil law on and mindset. Kurt first. Thanks. We'll see. Mark of Reality, welcome to Paralegal Status. USSJ4 Broly gifted a membership. Thank you. Also says, couldn't this trigger a snowball for any other potential POTUS every 4 years? Yes. State says no, it'll hurt their feelings too much. Happy New Year, brother. Yep. Yes. Yes, they just have to make a determination that he participated in an insurrection with a nebulous definition of whatever that is. Derek Nall says, sounds like the system is too broken and cluttered by useless soft lobby money and regulations. I see no out for this country. We did it to ourselves, but I see a right path and wrong path. Neither are safe. Well, safety has never been the hallmark of liberty, but we'll see how we go. All right, guys, thank you for hanging out again here on YouTube. We're going to make the switch over to Rumble. And again, slap that like button on your way out, and we'll continue over there. Also, Rumble, don't forget to click that thumbs up on your own. And we'll see you guys in just a minute. If you do not pop over to Rumble with us, thank you so much for a terrific year. Thank you so much for hanging out with me and listening to me scream about stuff at all hours of all kinds of nights. And I look forward to doing it again this next year. And we'll see you then. Have a good night, guys. Peace. Peace. See you on Rumble.